Oh dear. Okay. Shall I? Nobody has any ID? Okay, let's go. I'll give you some hints then. Okay. Why do they need protection? I'm sure you have come across this in the context of your projects, in your work. I mean, of course, they have higher risks of exploitation. This can be forced labor, discrimination in the context of recruitment. Of course, they are non-citizens in the country that they work. There's a lot of issues in terms of unequal treatment with respect to wages, with respect to access to employment, of course. I mean, frequently these are low-skilled workers that face most of the labor protection deficits. Often they're excluded from national labor law, and we're thinking a lot about those in the informal economy, those who are migrant workers, those who are migrant domestic workers or in agriculture. I mean, many migrant workers face multiple forms of discrimination, of intersecting grounds between, gender, race, ethnicity, indigenous status, disability, for example. And of course, many migrant workers are at risk of being in irregular situations. This can again be due to inequalities in the labor market, which are transposed into the international labor market. But I think it's also important to mention a little bit what are some of the labor protection deficits that we have found, and that I'm sure you will have also found in your regions, whether this is intra-region in the Africa region or whether this is when migrant workers go to other regions, like, for example, the Gulf, where there's an increasing migration from countries in Africa to the Middle East. So, I mean, what we found, of course, is there is quite a considerable migrant pay gap. I mean, research that was done in 2020 with pre-COVID data, of course, already, pointed to, an average hourly wage gap of almost 13% in high-income countries, but in some countries, this was going up to 30, 35, or 45, 40 plus percent. So migrant workers, particularly low skilled, were earning less than 40% than nationals. For women migrants, this was even more, and the overall migrant pay gap between women migrant workers and male nationals was up to almost 20%. I mean, wage-related abuses in terms of underpayment, non-payment of wages, of course, is a recurrent subject, and we have been developing guidance in that respect. There's also standards covering, of course, these issues. Of course, unpaid wages or systematic unpayment of wages can lead to situations of forced labor. Higher exposure to occupational safety and health risk is something we frequently see with migrant workers, and research is ongoing there too. And we have, of course, the fundamental conventions on occupational safety and health that are quite relevant here. Higher incidence of forced labor. I mean, the most recent estimates have pointed that out with respect to migrant workers. We can give data later on. I mean, like I mentioned already, discrimination and violence and harassment is quite frequent for migrant workers, and of course, trade union rights violations. And here again, research has pointed to some serious legal and practical obstacles for migrant workers in that area. So it's important to keep that in mind. The labor protection deficits and general protection needs of migrant workers when we go and look at the standards framework. So now I have a question again to you, and I'm trying to see if anybody's pointing into the chat. But I mean, do you think, in your view, that all ILO standards apply to migrant workers, or to all of them? Anybody? I don't hear.
Hi, Kat.
Hi, Austin.
Yeah, I think all labor standards, of course, and indeed should apply to migrant workers. But for the unique purposes that migrant workers or challenges migrant workers do face, additional measures are put in place, and that's why we have particular ILS pertaining to migrant workers.
Mm-hmm. So yes, there is the principle that all ILO standards apply to all workers, including migrant workers, irrespective of nationality and immigration status, unless otherwise stated. I mean, one example would be, for example, that a standard, which is a specific dedicated migration instrument, doesn't apply to all migrant workers, would be Convention 97. Convention 97 only applies to migrant workers in a regular situation, which is not the same for Convention 143, which we will see later. So this is what we mean with unless otherwise stated. So it could also mean that certain ILO standards, whether this is on wages, whether this is on OSH, whether this is on working time, on maternity protection, or on social security, that because of the particular situation of the worker or the migrant worker, that in practice, the standard may not apply. But this is, we're getting into a lot of technicalities, but this is what is meant by unless otherwise stated. So this also means that ILO, International Labor Standards, they apply to migrant workers, refugees, and displaced persons. And this is very clear from Convention 97. It's specifically mentioned there that it also applies to refugees and displaced persons. And since Convention 143, which is the supplementary convention to Convention 97, it doesn't specifically mention refugees, but the Committee of Experts has considered that, again, that instrument would also cover refugees and displaced persons. But of course, these are also covered by our fundamental conventions and other relevant standards. But we have to remember that states do have a sovereign right to regulate access to the territory and the labor market. So they can decide on what kind of migration policy, who can come in and to the territory and who can enter the labor market. Standards do not say something specific on that, but there are some rules to be considered, like, for example, specifically in the context of fundamental conventions that should apply. There should not be any trafficking, there should not be forced labor, there should not be any discrimination applied in the context of some of the rules or immigration acts in countries. Now, which are the ILO standards that protect migrant workers? Any idea? I'm trying to see if you put something in the chat. Anybody?
This is Kadis from Addis Ababa.
Yeah.
I think you had already mentioned some of them, 97 and 143. Yes. But I think the Domestic Workers Convention, as well as the Private Recruitment Convention 189 and 181 are also key when we talk about the protection of migrant workers. Those are a few that I could state. Maybe other colleagues can compliment. Over to you.
Thanks, Kiran. Yeah. So, yes, there are quite a number of standards that do apply, and there are different types of them. So there are the standards, which I've already sort of briefly mentioned, the ones that are specifically protecting migrant workers. And I give you a little bit more detail on those later on, which are Convention 97 and Convention 143 and their accompanying recommendations. The fundamental conventions, and there are 10 of them, and the protocol. So actually we have 11 instruments on fundamental rights. So 10 fundamental conventions and a protocol on forced labor. There are also the standards with express provisions on migrant workers, like, for example, what you mentioned, Kidest, was Convention 181 or Convention 189, or the standards on violence and harassment, or some of the standards on social protection. And then there are standards of general application, for example, on wage protection, Convention 95, or labor inspection, Convention 81 and Convention 129, or the employment policy convention, Convention 122, which is of general application. It doesn't have any specific mention of migrant workers, but it really does apply, and these are very important standards. So what are these dedicated standards on migrant workers? Before I go into that, are there any questions already or anything you want me to address right away? Nothing? I go on? All right. So yes, what are the dedicated standards? Like I said, we have the Migration for Employment Convention, and the recommendation, which were adopted 75 years, 76 years ago, and then Convention 143 and Recommendation 151, which this year we could commemorate the 50th anniversary. And that's maybe something to bear in mind, that last year it was 75 years that these instruments, 97 and Recommendation 86 were adopted. And this year we have the supplementary instruments on migrant workers. So it's the 50th anniversary. So those are the 4 instruments. If we go into Convention 97, so what was the context? I mean, the historical context, this was immediately after World War II. It was to facilitate movement of surplus of labor. The purpose was really to protect migrant workers from discrimination and exploitation. The scope is migrant workers and their families, but only those who are in irregular situations. And then you have certain categories that are excluded. Based on the definition itself, we're only talking about migrant workers who are remunerated. We're talking about migrant workers who are international migrant workers, so not internal migrants. And categories that are excluded are the frontier workers, the seafarers, because there was a wide range of instruments that were already addressing the maritime sector, members of liberal professions and artists on a short-term basis were also excluded. And then what is quite important in that convention is also the principle of international cooperation, where the importance of bilateral labor migration agreements is emphasized, particularly in situations where there are large numbers of migrant workers coming from one region to the other. The recommendation is also quite important because it has additional measures on recruitment, and it has a model agreement. And even though that model agreement has been adopted 75 years ago, it has actually still quite a few important principles relating to labor protection, relating to cooperation, relating to recruitment, or relating to equality of treatment, for example. So protection of migrant workers. So what are some of the main provisions? So first of all, in terms of protection, it's the convention has provisions that aim to regulate the condition in which migration needs to take place. So for example, there needs to be free access to information and services, which is Article 2. There needs to be measures taken to ensure that, to facilitate the departure and arrival and journey of migrant workers, their protection in terms of medical examinations, their general provisions relating also to conditions in which migrant workers need to occur, but also relating to bilateral labor migration agreements, savings and earnings that need to be when the provisions on services and earnings for which migrant workers have to maintain the decision. And then, of course, very importantly, no less favorable treatment. And this is the equal treatment provision of Convention 97. We can go to the next slide, Alex. Yeah. So the less favorable treatment means that the treatment doesn't have to be exactly equal, but it needs to be less favorable so it can be equivalent in its outcomes. So this doesn't mean that migrant workers have to be covered in an identical way under a Labor Act, but there can be different parts of legislation that ensure that when you look at this together, there is no less favorable treatment of migrant workers. Of course, ideally, migrant workers should be covered by the Labor Code or Labor Act or Employment Act, but this is not a requirement of the Convention. Also, that provision on no less favorable treatment is not asking the government to take active measures. That's a big difference with Convention 143. It's only saying that you cannot have any legislation, regulations, or administrative rules that cause inequality of treatment with respect to housing or social security or membership in trade unions or benefits of collective bargaining or from in terms of conditions of work, remuneration, and access to justice. So this is for you. It's very important to bear that in mind. Convention 97 doesn't ask the government to take an active policy to promote equality. It just prohibits unequal treatment. But of course, if there is legislation that allows for equal treatment, that there is no problem, the convention does require, and this is supervision of conventions, that of course this is also applied in practice. So there might be issues. You may have legislation that says men and migrants and nationals have to have equal wages in this or that particular occupation or sector. It doesn't happen in practice, so the government has to do something about it. So this is Convention 97. So it has 3 annexes, which are not so often mentioned, but they mainly deal with issues of recruitment, placement, and conditions of labor, and Annex 3 deals with customs. I think I mentioned already, no, I think we're first have to go to 143. Yes, Alex. So 143, 25, almost 25, yeah, a bit more than 25 years later, I mean, the situation has changed. There was a lot of, there were many migration flows. There was an increase in irregular migration. So the idea was also to facilitate and regulate labor migration flows, to suppress and address activities of clandestine or irregular migration of migrant workers, but also provide these workers with minimum protection. And finally, also, which is another part of the convention, is to promote equality of opportunity and treatment. So it's a flexible instrument, which has part 1 and part 2, which can be ratified separately. And part 1 is dealing really with migration in abusive conditions. So what I've mentioned, irregular labor migration, and also the human rights and other minimum standards of protection of all migrant workers. Part 2 is dealing with equality of opportunity and treatment and only applying to migrant workers in a regular situation and their families. So, like I said, part 1, all migrant workers, and part 2, only regular status migrant workers who are remunerated for work. Again, self-employed migrant workers are excluded from part 2, as well as are the exceptions like frontier workers, seafarers, and liberal professions, the same as in Convention 97, but also persons coming from training and education, and then temporary specific duty assignments. So, for example, the posted workers. Now, what is important, again, to bear in mind, so these are only exclusions and definitions for part 2, that is dealing with equality of opportunity and treatment. Part 1 is covering all migrant workers, including the self-employed, including the frontier workers, including the seafarers, including the students, including the specific duty assignments. Okay. So again, so part 1 is dealing with migration in abusive conditions. So very important, Article 1, which was actually adopted at the very end of the discussions of these standards, already the second discussion. Suddenly, this was an amendment that was requested by the workers group, that really there should be protection of basic human rights of all migrant workers. And that amendment was actually quite quickly adopted without much contestation. So what does this mean? Of course, this does mean the fundamental human rights that are expressed in human rights instruments, and particularly those that include the fundamental rights of workers, again, which I mentioned earlier. So the idea of part one is also to protect the regular status of migrant workers, which is really distinguished from the right to stay. So what that means is that migrant workers who are in a regular situation and who lose their employment, for example, because of injury, or because of economic downturning, they cannot fall immediately into an irregular situation. Their residence permit or work permit should not be immediately withdrawn, and they should be, according to the committee of experts, at least have the right to stay into the country until the end of their employment contract. Or sometimes we have countries that have allowed that they stay until their unemployment benefits, if they are entitled to those, have been exhausted. So this does not mean that migrant workers, for example, on a temporary labor migration program, have the right to stay eternally or for years and years. No, the idea is that at least they should have the right to stay and find alternative employment or training for the duration of their employment contract. And then for migrants in an irregular situation, they should enjoy equal treatment with respect to some rights arising out of past employment. And these are remuneration and social security benefits. So what is quite important here is, and this has happened, we've seen this with COVID, but also in the context of conflict, and we see it today as well, that migrant workers, when they end up in an irregular situation, their wages are often outstanding, and they have to go back and they will never see their wages paid. Or even migrant workers in an irregular situation, in some countries, they may contribute to social security. And also those benefits, if they are contributory benefits, they also are outstanding and they should be paid. But this is really a very difficult question, and therefore access to justice and access to legal proceedings in this regard, giving migrant workers, even in those in an irregular situation, the right to submit a claim on non-paid wages or non-paid social security and other benefits is quite important. And this is why the whole issue of cross-border justice or access to justice is also something that is now being more and more researched, and ILO has also produced a paper on that. It is something that we need to further deepen our work on. Another principle there is that migrant workers, if they are in an irregular situation, if they are being expelled, they should not pay the cost of expulsion. And then going to part two, yes, just on part one still, it has a number of measures that are really requiring governments to take measures to detect and suppress and prevent irregular migration, and also to pursue trafficking of migrant workers, and to prosecute those who are organizing this from wherever the country this happens. So part two on equality of opportunity, and I mentioned it before, this time, this part two is built on Convention 111. Convention 111 on equality of opportunity, on non-discrimination in employment and occupation. And as Convention 111, this part two also requires the government to adopt a national policy to promote and guarantee equality of opportunity and treatment with respect to employment and occupation, trade union rights, other collective grievance, cultural rights, and social security for migrant workers in a regular situation, And this, with regard to of course, a broad range of areas, like, because employment and occupation, of course, also covers conditions of work. And there are several measures that countries need to apply progressively, which is repealing discriminatory legislation, promoting actively equality of opportunity in practice, adopting this national policy and implementing it, and also, which is not mentioned on the slide, is a policy of is a social policy, and also ensuring that migrant workers can maintain their ethnic and cultural identity. But part two does allow some restrictions on access to employment, but only for a limited time. So, for example, the free choice of employment can be restricted for a period of maximum 2 years. For example, migrant workers can be restricted to one particular sector or to an employer but only for maximum 2 years. And then the labor market in a way should be opened up. There can be restrictions on limited categories of workers and employment or functions, particularly in the interest of the state. And for example, this could be in the public service, military, security functions, for example, but it cannot be broad exclusions. So no general exclusions across the board for all migrant workers. Now, on this free choice of employment, and that is actually, I mean, linking or allowing that a worker can only work in one particular sector or employer for a maximum period of 2 years, of course, this leads to, we have seen, quite a number of abuse. So the convention doesn't say that this is not allowed to link to one particular sector or employment. But of course, when there are issues of abuse, and then we're coming back to fundamental rights, and we're coming back to part 1, is that in cases of abuse, migrant workers should be able to file complaints and should be entitled to compensation and access to justice. So these are two different issues, but often what we've seen is that policies that are linking the work permit to the residence permit and to one employer, that this creates, of course, quite a lot of abuse. And we've seen this in the context of employer tied and sponsorship systems in the Gulf. And then the convention also has a provision, a quite general provision on the recognitions of diplomas and qualifications, which a key principle in both instruments is really international cooperation. I've mentioned it before, and this relates very much to bilateral labor migration agreements. So some of the key features of both instruments are, again, recap, they do not affect the prerogative right of states to determine admission of nationals for employment. They are relevant to both countries of origin and destination. And if you take them together, I mean, really, what's to remember is all migrant workers should enjoy basic human rights. And this is especially when in your region, countries have ratified all the fundamental conventions. I mean, this is really already quite significant in applying that particular provision in practice. And once they are admitted to employment, regular status migrant workers should equality of treatment, and really under Convention 143, equality of opportunity and treatment with nationals. Social consequences of labor migration need to be addressed, and labor migration processes need to be regulated, of course, within a rights-based framework. So I'll pause here. Any questions for now? Any reactions? Any questions you have on these conventions? No, nobody?
I can't.
I can't hear you very well. Who is speaking?
Hi, can you hear me? This is again this from ILO, the technical officer here based in Addis Ababa. Thank you so much for this. I just have few clarifications on the two conventions. Regarding the Convention 97, when we say no less favorable, how do we measure that? Maybe I give you my questions and then you can respond. So my first question is, how do we actually measure when we say no less favorable? And my second is, considering that C-143 is more or less a better version of Convention 97, considering the protection of migrant workers' rights, hasn't there been a thought of more I don't know how to put this, of considering Convention 97 more obsolete convention and trying to, take it out and then replacing it by Convention 143? Isn't that an option? Is it possible? Is this something planned within the ILO? Within the ILC? Another question with regards to 143 is on the duration of stay. It's indicated that when employment contracts are ending, is it when employment contracts are ending, or is it when their employment contract is stopped without the end of the contract. I don't know if I'm clear, but I'm asking this to understand if, as ILO, we are promoting the provision of work permits that go a bit beyond the employment contract.
Can you repeat your last question?
My last question is regarding the duration of stay.
Yeah.
For that, are we considering the end of the employment contract, the initially signed employment contract, or are we thinking that if the employment contract is cancelled before the end of the contract, then the duration of stay should be considered so that benefits of employment can be taken into account? Or are we considering the provision of a work permit for migrant workers that is beyond the employment contract?
Yeah, okay. All right, some of it I will address later on, but maybe that will help to maybe not to cut some slides. Okay, first of all, how do we measure unequal, less favorable treatment? Like I said, it's not about identical treatment, so less but it is an equivalent treatment. Now, the provisions are only legal, so this is unfavorable treatment or unequal treatment in regulations, laws, administrative policies, and rules. So it is something that is laid down. So it's not like a practice. It's not like there is a practice of treating them unfavorably outside of the law. Of course, the law needs to be applied, and then so if you have, so in terms of examples, if you have a law saying that or a collective agreement saying that migrant workers should be paid less than nationals, then you have less favorable treatment in the legislation. If you have social security legislation, which was the case in Malaysia, I think, where migrant workers were covered by two different systems, and under the systems that migrant workers were covered in terms of workers' compensation for injury, migrant workers, they got a lump sum and they have to go back. While nationals, they were paid out on a regular basis, monthly. They were paid an amount of compensation, and this led to less favorable treatment. And it is based in it has its ground in the legislation. So then if you have legislation where the labor code said this applies to all workers, migrant workers should be treated equally, there should not be discrimination. But then if you see that in practice, migrant workers, based on what the unions say or based on complaints, that migrant workers, that the law is not applied and that migrant workers do earn less or are in poorer working conditions or suffer from higher occupational safety and health risk, then your legislation is not applied. So this, the Committee of Experts has consistently asked governments that, okay, great, your legislation does not have any unequal or less favorable treatment, but how do you apply this in practice? Because we hear from the unions that there is a problem. So that's one thing. Then in terms of obsolete, I mean, no, 97 is absolutely not obsolete. I mean, what the Committee of Experts found already in 1999 and 2016 is there are some details of the provisions, and these relate mainly to issues relating to medical examinations, because 97 was adopted when migrants were still, I mean, traveling by boat a lot, and there were conditions of hygiene, and so that provision is mostly that. Now, that provision in 97 on medical examinations, that they should have been entitled before and upon arrival to have access to such medical examination. It's not access to healthcare, right? It's really a medical examination to see if they are in good health. If those medical examinations are discriminatory and if they are testing for pregnancy or testing for HIV, then this is now being addressed under that particular article. But there was a question to say, well, some of this is maybe not the way migrant workers travel today. 75 years later, I mean, it's no longer mainly by, I mean, in most regions, we have, of course, irregular migrants, but they're not covered, traveling by boat and with dramatic situations, but it's really related to that conditions of hygiene during travel. And then there was also a discussion that some of the provisions of 97, they were no longer relevant because temporary labor migration was much more than permanent labor migration, but temporary labor migration is covered by Convention 97. The principle of international cooperation is still very relevant today. The principle of equal treatment is still very relevant today. And 97 is really covering this principle. You should not have unequal treatment. You should not discriminate in remuneration, conditions of work, in social security, in trade union rights, in access to legal proceedings, in terms of housing. I think this is quite relevant today. And this is also what the constituents thought when they adopted Convention 143, and even later during the assessment by the Committee of Experts, that 97 still remains in terms of its principles, the basic instrument on which Convention 143 is built. But Convention 143 is also built on Convention 111, on the Fundamental Convention on Discrimination in Employment and Occupation, because that convention does not have the ground of nationality among the 7 listed prohibited grounds in the convention. So Convention 111 covers migrant workers and protects them against racial, ethnic discrimination, religion, gender discrimination, political opinion, social origin, and national extraction. But national extraction is more about citizens of a different origin in one particular country. So, for example, in France, Bulgarians and workers from Mali, but who have been naturalized to French citizens. So, which is different from nationality. So nationality and citizenship is not a criteria under Convention 111. So this is why the constituents, when adopting Convention 143, said, look, this is a gap. So we also think there should be equality of opportunity and treatment among migrant workers and nationals, and the ground of nationality should be a prohibited ground. And then you have the same kind of measures or similar kind of measures that countries have to take as you can find in Convention 111. So it's really a supplementary convention. Convention 97 has still basic provisions which are relevant today. I mean, like you need to have free information and free services to migrant workers. Adoption of bilateral labor migration agreements, the provision of equal treatment, like I said, migrant workers who are in a permanent situation, who are permanently admitted in the country and who have work injury, they shouldn't be sent back to the country. They have been there, accepted on a permanent residence permit. If they have a work injury, they should receive compensation in the country of employment, and they shouldn't be sent back. So this is about, and this is perhaps your question also related to why are there certain myths and realities on these conventions. And for example, when in relation to Article 8, Convention 143 doesn't require, and this is a fear of countries and prevents them from ratifying, it doesn't require when migrant workers lose their job to renew their contract, so they have to stay forever. What they have to do is, until the duration of their residence permit or work permit, which is the longest, they have to be able to stay in the country and find alternative employment and training. So of course, in some situations, there may be only 2-3 months left. That's possible. So there are some limitations there, but that normally is accepted. The convention doesn't require to governments to renew work permits. Of course, if the work permit is imagine the person has the worker has a contract for 2 years. After 13 months, she loses her employment. she loses employment, she should not find herself immediately in an irregular situation. The residence permit or the work permit, if she also has one, should not be withdrawn, and she should be able to stay at least until the end of for the remaining 11 months, at least, there. I mean, the convention doesn't say it doesn't provide any guidance further on the, in this or that case, you should also renew the work permit. But she should not find herself in an irregular situation. And during those 11 months, she should be able to seek alternative employment. And then with a permit, if she finds a work permit, at least until the end that her original contract was taken, or maybe longer, if the legislation allows for that. But the convention doesn't say you should give a work permit beyond the original contract, duration of the contract of employment. So, but the minimum is no lose of your regular status, and you should not, you should be able to be given a chance to find alternative employment or training for a while. But if you are fired, you lose your employment because you're fired, the recommendation provides that you should be able to appeal against that decision of termination of employment. And during your appeal, you should be given sufficient time to remain in the country until the outcome of that case. Now, of course, the situation is often that in most countries, I mean, the judicial system, it's a long time. So this is often where countries have problems, but this is the whole issue of access to justice, of course. But the principle is that if you are terminated and you think you're unfairly terminated, you should be able to file a complaint, you should be able to file appeal, and you should be given sufficient time to see what's the outcome of the case. And if it was considered to be unfair, you should be allowed to be reinstated or to be compensated. This is what the recommendations say. Is that clear? Or you need...
Yes, that's very clear. Very
okay.
Clear. Thank you so much.
So, myths or facts. So it doesn't affect the sovereign rights of states regarding admission of workers. It can attract migrants in an irregular zone. So this is about, this is any reactions from you I need. Does it affect the sovereign right of states or not regarding admission policies? Yes or no? The conventions, I mean. I think I mentioned this 3 times. It does not affect. Now, are 97 and 143, are they made in a way that they actually attract more irregular migration? Yes or no? Are you all sleeping? I don't see any answers in the chat. Maybe you're disconnected. This is a question to you. So do you think those conventions were adopted in a way that they would attract irregular migration? They would promote it? No. On the contrary, part 1 of Convention 143 is exactly trying to address it. And it's actually, the conventions are meant to regulate conditions in which regular migration should occur. So it, of course, applied to both destination and transit countries. It does not allow access of migrant workers in an irregular situation to social protection broadly. So Convention 143 only says that if migrants have contributed to social protection, so contributory benefits, if they have to leave the country, they should be entitled to receive those. But the convention does not say migrant workers in an irregular situation should have access to social protection equally to other migrant workers or nationals. And another question, yes or no, require development of a specific equality policy? Yes, under Convention 143, Part 2, but not under Convention 97. So let me, I'll leave this because you will get the presentation, because I see we're already 11. So if you have no further questions on these standards, I mean, let's continue with the presentation. I just wanted to, coming back to the earlier questions I answered, is, I mean, it's really important when you talk about these instruments to assess their flexibility. Like Convention 97 has also annexes. It's not mandatory to ratify those. You can ratify all three. You can ratify two. You can ratify one or none. Part 1 or Part 2 of Convention 143. So it's flexible. Also, the adoption of the national policy under Convention 143, you can adopt this in stages. It doesn't have to happen overnight. The validity, the convention still recognizes that you need to take into account labor market needs, and this is also clear from the recommendations. They're still valid in a way that the principles allow to address labor shortages. Definitely, they aim to combat discrimination and promote equality of treatment. And the relevance is that they really provide protection against wage cuts when economic downturn, in terms of requiring equality of treatment with regard to conditions of work. It avoids social dumping. This is a reason why they should be ratified, because of the protection framework they provide. And the scope is, it's persons who have migrated or will migrate for reasons of work and remunerated work in all sectors, permanent, temporary, seasonal work, and as well as refugees and displaced persons. So there is a little video, which I will maybe not show now, because Alex, what do you think? We may have to proceed with the
think we
next
can
slide.
proceed, and you can, watch it
After.
on your
Okay.
side as a recap of this session, maybe after the
Okay.
training, because it's still 10 minutes.
Okay, so Alex, would you, maybe I give the floor to you for the next slides, and wherever I need to come in, I come in.
Thanks, Kat. So now we've seen in detail the dedicated instruments on migrant workers. But as we discussed in the beginning, there are different type of standards that are very important for migrant workers. And so another very important set of standards are what we call fundamental standards, fundamental principles and rights at work. Do you have any idea what those fundamental standards are in terms of topics? When we speak about fundamental rights, what does that mean? Any theme that comes to mind? We kind of call them, the human rights of the labor rights, like really the core of the standards. So what do you think they are?
Non-discrimination, freedom of
Yes.
association and collective bargaining.
Yes, indeed. Any others? I see in the chat, forced labor, child labor. Indeed, correct. And OSH. Thanks, Eliza. Yes, that's the newest addition to this category of standards. So as Kat mentioned in the beginning, there are 11 instruments, fundamental instruments, 10 conventions, and 1 protocol. And you can see here that this covers 5 big subjects that you just named. So there's 2 conventions on freedom of association and collective bargaining, 87 and 98. 2 conventions on the elimination of forced labor, Convention 29 and 105. But there's also a protocol that was adopted in 2014, a protocol to the Forced Labor Convention. And then there's the abolition of child labor with Convention 138 and 182, elimination of discrimination, Convention 100 and 111, which we already mentioned several times. And much more recently in the history, there was the addition of 2 conventions on safe and healthy working environment, Convention 155 and 187, which is a very important addition. And some of our constituents still forget that these are now part of the body of fundamental instruments. So those conventions, they're a bit special because some of them, they specifically mention migrant workers in some of their provisions. So we could also say, you know, when we looked at the different type of standards, that there are express provision in some of those instruments targeting migrant workers. But some others don't specifically, you know, mention migrant workers in some of the provision, but they do apply. And they're quite special because there's also a declaration. We will not enter into too much detail, but there's a declaration that was adopted in 98. That means that it's, in fact, even if a country doesn't ratify one of those 11 instruments, they still have to report every year into a mechanism that is called a declaration mechanism on what they are actually doing to implement those conventions. So often when we speak also with constituents, we mention that, in fact, you know, even if you don't ratify, you have to actually report what the country is doing to implement those conventions. So that's why they have this special status. I mean, do you have any experience, or do you know, what's the situation in terms of ratification of those conventions in the countries you covered, or some of the comments that have been made by the Committee of Experts, for example, on those conventions in the countries that you oversee? Because in fact, they can tackle a lot of the issues that Kat already talked about. For example, if we take the Forced Labor Convention, there has been a lot of comments from the Committee of Experts that speaks about those employer-tied visas, that are also problematic because they can lead to forced labor in certain situations when there is also, no right for migrant workers to organize or to collectively bargain, very limited access to justice. So under those conventions, there are also a lot of different situations of migrant workers that are dealt with. I don't know if we want to enter, Kat, into too much details on the examples or if we should move on, but if you want to mention a few examples, perhaps.
Yeah, I was I mean, forced labor is the one that is actually the most important one, and not the most important one, but the one that has been mentioned most by the supervisory mechanism and also by the unions that affects migrant workers. But I mean, if you look at the others, I mean, I was just looking at the earlier this morning at the report of the Committee of Experts on the supervising the conventions and recommendations. That is just online yesterday. It was online, so it's quite important to have a look at that. And if you do a search on migrant workers, you can see that even on freedom of association, there are quite a few comments about the fact that migrant workers can join trade unions, but they cannot form trade unions. So there are legal restrictions on that. They have to have either so many years of residence, or they have to have the nationality, or they have to be a national to be engaging in trade union office. So they can't take part of the managing committee of a trade union. And they cannot engage in collective bargaining, which is quite important for sectors in which many migrant workers are employed. So, and for example, Mauritius, in Mauritius, the Committee of Experts was requesting that the government would increase its efforts to improve inspection and awareness raising on collective bargaining for migrant workers, particularly in sectors that are employing many of them. And this was particularly related to collective bargaining in export processing zones, because they had noticed, based on information from the labor inspection, that there were actually a decrease in collective bargaining agreements and in inspection visits related to that. And also, it wasn't really clear whether any collective bargaining agreement would apply to migrant workers in the export processing zones in Mauritius. So this is how, for example, Convention on Freedom of Association are being addressed. And another issue on discrimination is that many, particularly the Gulf countries, but also Korea, countries in Europe, that have ratified Convention 111, the Committee of Experts has addressed extensively the situation or the possible discrimination of migrant workers based on race, ethnicity, color, combined with gender discrimination in these countries. And it's very useful to look at the comments of the Committee of Experts under these conventions, Convention 111, often combined with Convention 29, because in the Gulf, these are one of the few conventions, fundamental conventions that have been ratified, and it's really giving you quite a substantive picture of what the issues are in the region. And I mean, on occupational safety and health, these are the least ratified conventions together with freedom of association. So there hasn't been quite a lot of comments from the supervisory bodies in that respect, but that will come. Okay, I stop here.
Thanks, Kat. Are there any questions on those instruments and how they apply to migrant workers, or any comments? Elisa is in fact saying that the Committee of Expert report is 1,000 pages plus.
Yes, but you don't have to read it from A to Z unless you really, really want to fall asleep. But it's actually, there are very interesting comments. These are only observations, because the Committee of Experts adopts observations and direct requests. And observations are usually cases where there is a lot of, I mean, there were quite substantial issues in terms of application, there are violations, there's non-application, or there are important cases of progress. And there are comments, important comments from workers or employers organizations. So it's a big report. It's also a big report because it's apparently it's also related to the font. I mean, if you check, maybe they could have made it a bit smaller. But no, there's a lot of, I mean, the ILO has adopted a lot of conventions. There's a lot of reports that have to be addressed. So you can imagine the standards department workload in preparing that work for the Committee of Experts, and the Committee of Experts workload in dealing with it. But there are quite a number of observations that are important. I did a search, just migrant or migration in the report, and it has over, I mean, close to 600 references. So I mean, some of them, of course, I mean, there are observations on Convention 97 and 143. So, of course, that's more, I mean, more keywords. But I mean, really, check it. And you can do a search for your country and for particular conventions in that report. But there's other ways of searching that too, but we get into that.
I think we'll show you, and we'll do also a quick recap on how to use the Normlex website, which is a bit more easy to navigate than the reports. But maybe just right after that.
Yeah, let's see, because I think we need to advance a bit more quickly. So I mentioned some of them already, but there are other standards that are also important. I think I saw some in the chat, like 181, 189, 155, so which are mentioned. But I mean, there's a whole list of conventions, whether these are relating to social protection, to wages, to domestic work. All of these are conventions that either have specific provisions or which are of general application that I mentioned in the beginning, and that you should actually bear in mind when you're looking at the situation in your country. Or the situation from your country of migrant workers going to another country, it's always very useful to see what conventions have been ratified by your own country and by the country of destination, because it gives you a more complete picture of what can be done and what are some of the recommendations of the supervisory system. So yeah, we wanted to ask you, and I think Alex was already asking for that earlier. I mean, do you know the ratification status of any of these instruments in your country, like the fundamentals, but also the others that I mentioned? And again, I think it's the first thing to do when you try to assess the situation of your country and of the countries of destination in the context of migration. What is the ratification status of the fundamentals of the Migrant Workers Convention, the Wage Protection, Convention 181 on private employment agencies, for example? It's really key. And maybe where are some interests of ratification in your country? Is this something you regularly look at? Is this something you would just automatically, which comes to your mind when you do an analysis, for example, of the situation? How many of you actually look at the ratification status of several standards in your country?
I can
Anybody?
come in.
Austin?
I can come in with that. Yeah.
Yeah.
I just wanted to mention, I mean, in terms of the labor migration ratification, so the countries I cover, I think Liberia, Sierra Leone, Nigeria are doing quite okay. We still need to push for ratifications in Ghana. However, what we also observe is that one of the standards that really has less appetite by the government, going beyond lip service for ratification, is 189. For instance, in Nigeria, this has been on the table for a long time in terms of advocacy and engagement towards its ratification. Interestingly, when we did push for ratification of 143 and 189, 189 accompanied the recommendations, but then the government dropped 189. I mean, it's not unconnected to some cultural preferences and dynamics in the region. So, yeah, this is a part of the things I wanted to share. And just going back to other aspects of the presentation that also relates to fundamental principles, really. So one of the things we did observe in Liberia, for instance, was that there are prolonged cases pertaining to fundamental principles that pertain to freedom of association and collective bargaining. I mean, CAS has been providing series of comments in that area. However, the learning for me particularly has been with regards to where there's no effective social dialogue systems and processes at the national level. It really becomes almost a no-brainer to engage, as it's almost impossible. So, and then the challenge has been the collapse of the social dialogue structure at the national level there, which has really affected the work of the ILO. My question would also be around where comments do exist that do not necessarily pertain to the situation of migrant workers and their families amongst those fundamental principles. But generally, there are comments on the particular convention. How do we navigate, or how do we engage? Do we take it, that is not really pertaining to the work that we do, since, particular comments were not made to protection of migrant workers? Thank you.
Yes, no, this is a very good question. Of course, I mean, I think my advice would be, and this is what I would do, is I would not limit myself to comments that only have comments specifically that mention specifically migrant workers or foreign workers or non-nationals in the text of the. I would say, look, I'm working on Nigeria, and I would look what are the comments of the committee of experts that are pending for my country. And sometimes, as you say, this has no reference at all to migrant workers. but it may give you a situation. For example, there may be a comment on labor inspection, but it may not have addressed yet because the committee of experts has its limitations, and sometimes, I mean, it's also related to the vast amount of information they have to process. But a comment on labor inspection, and which is, well, there is a problem with labor inspection services. They are not independent. There's lack of resources. There are issues of labor inspection in certain sectors, and you know for a fact that in those sectors you have quite a number of migrant workers. So this would, even though the committee of experts may not mention it, it is important for you to know that this is happening. Now, between that and then specifically starting to say that you have to talk to the government, that they have to do something specifically on this overall general comment, because they're also standard specialists in your teams and in your region. And you should very much consult with them on how you would address this, to what extent you can deal with this in the context of migration, and what would they do. Because standard specialists in the region have a responsibility to assist the government in following up on comments of the committee of experts. But of course, I mean, the most relevant are those that have specific comments in there with respect to migrant workers, or in a sector that you know, or a situation that this is particularly relevant, even though there is no mention of migrant worker. But what I'm saying is that it's important to bear them in mind when you are looking at the context of your situation. Austin, is that so? What I would like to do is just very quickly, because I have very little time left, is to go to the page, Alex, on NormLex. Normally, yeah, how do I, because, okay, Alex, can we open this, the thing? Okay, NormLex is really an incredible source of information. I don't know whether it works. Perhaps
NormLex.
No. You know what? Because we don't have much time, let me explain just on the basis of the slide, and then I commit myself, for those who are interested, to really do a separate session on how NormLex works, because it's really, you have it. So, okay, if you look at NormLex, you can see on your right, you can look at what are the instruments, relevant instruments, if you want to find instruments. If you want to find what is the ratification of certain conventions, or per country, but you could also look at country profiles, which is either you click on the name, on the letter of your country. Maybe we take a country of the region, English speaking, not Burundi or something. Let's take Nigeria. Why don't we take Nigeria, that Austin was saying, Nigeria. So you have Nigeria. Here you click on Nigeria, and there you can see the latest ratifications in Nigeria were those. See, 143, 181, 187. Then the reporting schedule for Nigeria, can you click on that? Yeah. So you see that in 2024, Nigeria had to submit reports on those conventions, 11, 81, the MLC, and so on. And then it also says whether this is a first report after ratification, or whether there was already a previous observation or direct request from the committee of experts. And then you can see for the next years, yes, in 143, in this year, Nigeria needs to submit its first report on Convention 143 and Convention 181. And this, Austin, is relevant for you, because you could then see to what extent, what is the kind of assistance the government would need. You don't write the report, of course, but you can help the government to indicate, okay, this is the type of information that would be useful. I mean, in terms of all the laws and regulations, the policies, the practical application, and also, of course, the unions could also submit communication or an observation on what is not working so well in the context of that convention. So they have to submit a first report. And then you see for the next year, yes, you're right, Austin. A formal request already has come for ILO support, but ILO support on reporting, is that what you're saying?
Yes, precisely. I mean,
Right.
the report is due by the end of August.
Yes.
So, yeah, I mean, I can follow up bilaterally with
Yeah,
you.
but you need to talk to the standard specialist because this is
Yes,
something,
yes,
but
I'm
it
in
would
touch with
be,
Faisal as well already.
yeah, it would be very good if they can, because they're often also some of these countries have also ratified the UN Convention on Migrant Workers, to which they have to report. So what is also important is that you don't use this double reporting. Of course, they have to report to the UN, to the Committee on Migrant Workers, who is the supervisory body of the UN Convention. But often that information, if they have already prepared the report, has been collected. So they can use that information also to integrate that in the ILO report they have to prepare. They shouldn't do double work. And I think Nigeria might actually have ratified the UN Convention. I'm not sure. But this is also something that you could say, look, you have already collected some of that information that because you are reporting also to the UN and you can use that, but you also have to, I mean, you have to link it to the provisions of Convention 143. So, okay, and then can you go back? So then in terms of a search, if you go to supervising, for example, you can supervise, you can find the search you can supervise by country, which we actually did, but it's search by supervisory bodies. There you can say, for example, I want no, not countries. You could say then you do a word search. For example, I say I want to know in the year 2023. You do 23, or you can do 24 is the last one. 24. The report of 24. Yeah. No, take 23 because I think it may not be online yet. 23. You can say, I want to see how many conventions have something on migration. So you put in the search, you put migrant, for example. Yeah, and then you do a find. And you see, so these are all the comments that may have a comment. So you have a direct request on Afghanistan, Albania, Algeria, Antigua. So, and these are all the different conventions that have comments by the committee, either a direct request for further information or an observation that were adopted in 2023 by the committee of experts. So you see, this also shows you the range of instruments that are applicable. And it actually comes back to what we said earlier. There's all these standards that apply. There's some that are particularly relevant, like the fundamentals and other, but you see, Ethiopia has so there's an observation that was adopted in 23. The committee always meets at the end of the year, and that its report is published and discussed at the conference next year. So the report of the committee that met in 2024 is now online, and it will be discussed in the Committee on the Application of Standards of the conference in 2025. And that is a standard standing committee. Okay, this is very briefly NormLex. I think I need to continue. But like I said, I really commit to, if you think this is useful, and please let me know, or let Samia know that to do this sort of separate little training on how to best use NormLex. So okay, how do we use standards in the daily go into supervision for just quickly on supervision. Is the supervisory system is we have a regular supervision, which is the committee of experts, which adopts observations and direct requests, and observations are published in its reports. Direct requests and observations will both be online, but for the session of 24, you need to wait maybe a few more weeks until these are all online, but the report of the committee is online. And the committee also adopts or has general surveys, particularly on migrant workers. For example, 99 in 2016 were specifically on Convention 97 and 143 and the recommendations, but other general surveys on occupational safety and health, on labor inspection, on employment instruments, on the care economy, on Convention 189 and 149. They're also quite relevant. And if you do a search and you look at them, they have very useful provisions on what the supervisory body says about the application of those conventions to migrant workers. So that's a big source, an important source. So the regular supervisory system also has the conference. So the report, as I said, will be discussed at the International Labour Conference, as will be the general survey. And then you have representations and complaint on ratified conventions. So a representation can be submitted by workers and employees organization on the non-observance of a convention that another country has ratified, or the country has ratified. For example, there was a representation by the Philippines on non-observance of Convention 97 in Hong Kong, China. And then a complaint is submitted by a delegate to the conference for non-observance, and an important example is, for example, the complaint that was submitted to Qatar, which led to then the tripartite agreement and the technical cooperation program in the establishment of the office, etc. But this is a combination of how regular supervision on Convention 29, Convention 81, and the complaints procedure work together to then create and situate the problem of those conventions in Qatar and its follow-up. And then you have the Committee on Freedom Association, which are particularly focusing on Convention 87 and Convention 98. And they don't need to have ratified those conventions to be subject to a complaint before the Committee on Freedom of Association. And examples were Malaysia, Spain, what else? Korea are examples that just quickly come to my mind on the application of those conventions to migrant workers, even though in some countries like Korea at the time, those conventions were not ratified. Okay, so in terms of your daily work, we made a slide. Can you go on? Yeah, a bit further back, Alex. Yeah. So where are ILS essential in your work? Of course, when you draft development project proposals. I mean, like I said, you need to look at the context. That also includes the conventions, relevant conventions. Have they been ratified? Have they been commented by the supervisory system? Implementation of project activities, like have there been follow-up? Again, comments may be relevant. Prospects of ratification you may wish to address. I mean, yeah, there is a need I think there is a need also for you that you're able to explain the basics on standards, specifically those related to migrant workers. I mean, at least the basics to the constituents. I mean, they're relevant, of course, in providing comments to draft laws and policies. I mean, these have to be in line, particularly with ratified standards, but also with the principles of non-ratified standards. In doing research, and also in supporting the implementation of conventions. Yeah, we can go on further. I'm not going to go into the BLAs because I don't think we have time. And then there are other key normative frameworks. I mean, they are the UN conventions, but I'm not going to go into a lot of detail there too. I mean, it's in the slide. Of course, you always look at also those, if they have ratified those conventions and if there are any recommendations by those treaty bodies, that's important. And then go on, Alice, yeah, go on. I think we should not go into that because there's no time. So resources for you. So there are a number of resources. I mean, we have a slide here with the hyperlinks. Of course, Normlex is a big one. The rules of the game, which gives you, the latest version is from 2019. So I think it's quite up to date, but I mean, Norms is usually working regularly on an updated version. So the rules of the game gives an explanation of the supervisory system and also per standard, some explanation and summary. We put a link to the general surveys, like I said. The one on the migrant workers are important, but not only. You have other more recent general surveys that are quite relevant. And then there is a list of resources related to irregular migration that we did, on freedom association, on wage protection, the global guidance on BLMA, research on the migrant pay gap we did. And then there are a forthcoming brief on social dialogue and labor migration governance, which will be very soon online. And then we're working on a brief on the safe and healthy working environment of migrant workers. And a guide on labor standards and labor migration. But those are forthcoming for this year. So look out for them. I will let you know. And then, of course, finally, who do you need to approach if you need help on ILS? I mean, first of all, in your region. I mean, you have a number of standard specialists in your region. You have Amanda, you have Jose Blondin, you have Faiza, and you have now recently Thomas, who has arrived in Cairo. And of course, me and Alex in Migrant, first contact point in Migrant on standards. But then you have also the team in norms, Cécile Balima, who is in charge of Convention 97 and 143, and also 111 and 190, who are quite relevant. And in relation to 181 and 189, it's the team led by Krum Markov. And then on other topics, if you need somebody in norms, I mean, please contact us. We will then get you in touch with them. But also in terms of Convention 189 and Convention 190, it's quite important to involve Claire Hobden from InWork and Valentine Begini, who is working on those conventions in JEDI on violence and harassment. So I think that's it. Right. So I'm really sorry we have to rush through this. I realize it's a lot, but please let me know if you wish to have either individually or in group some additional explanations. I'm here for you. If you need any help, please, after this, let us also know what are your needs, your concerns, where do you want us to give you assistance, and where do you think also you can contribute to the promotion of these standards. I haven't discussed yet the whole issue, and that's probably necessitating a separate session, is when the Office of the High Commissioner asks for different countries, and this is often now at regional level, to provide information on the application of either the Convention on Migrant Workers or on CERT or CEDAW, some of the UN conventions, which then goes often through the team, the UN network. But for ILO information on the treaty bodies, recommendations, and those conventions, because ILO always provides a written and oral contribution, this should really come to us first. There should not be any parallel system. So if you get that kind of invitation to contribute to a regional or country level report for any of the treaty bodies, please let me know, and we'll discuss. Okay, that's it. Are there any very quick questions? Because I actually need to leave soon because I have an appointment for which I can only spend another minute before I really have to disconnect. Okay, Kidist, I see you have a chat. Yeah. Yes. I think Kidist, I mean, you're right. I think on the MOUs and the BLMAs, I know you would want to have discussed that, but since it's of course, they have to be standards-based and rights-based. But I think this merits a separate discussion, and we're happy to do that. Perhaps what I would like to discuss, if there are any questions that you have now or in the chat, Alex, if you could stay a bit longer and take those, and then we can either give information in writing, or maybe some of those you can reply to. But I'm happy to provide any replies or feedback later on. Okay, is that fine with all of you? Okay, so I have to leave. I hope this was useful for you. I hope you got, I mean, really in a nutshell, most of the explanations. It may have been a bit technical as well, but please, I'm here if you have any questions. I'm your focal point. All right. Bye, everyone. Bye.
Bye-bye. Thank you.
Bye. Bye, Maista.
I think we're here, right? But yes, if you have any other questions, also suggestions for additional sessions. I mean, I see the MOU or BLA session. I think we could dedicate definitely an hour and a half on that too. But if you have any other suggestion, let us know and we can try to organize that in the coming weeks. So yeah, don't hesitate to reach out. Thank you very much, and maybe over to you, Marco.
Yes, thank you, Alex, and thank you to Kat, who's no longer here. But thank you for the very detailed presentation that you both gave. It was really interesting, I mean, also for me in HQ, but I'm sure also for the Africa colleagues. And I would just like to remind everyone that they have the presentation, the video, and all the relevant material in the eCampus, so they can refer to that one. And if there are any pressing concerns, they can contact us and or join the French version. They speak French this afternoon. So thank you again, everyone, for the participation. And
Thank you. Bye, everyone. Have a good day.